it possible this morning, but sometimes it's not possible for everyone to be physically present. So I'm going to hand it over to Phil Weiss, who is the founder of New York Legal Hackers and instrumental in the growth of the legal hackers movement. We've prevailed upon him to run this next session on crowdsourcing the law. You all know about crowdsourcing. Finally, law is catching up.
Thank you, Professor Askin. Thank you all for coming. As Professor Askin mentioned, I'm founder of a group called, a national community called Legal Hackers. And if you haven't been to one of our events, essentially what we do is each month we take an issue at the intersection of law and technology. We explore that issue, explore why it doesn't lend itself towards traditional regulatory methods, and then propose new solutions. Just about a month ago, we did a hackathon on data privacy. That was great. We did it in 3 venues in New York, San Francisco. Hello? Thank you, Professor Askin. Thank you all for coming. Wow, I don't want to talk anymore now that I've heard my own voice. So we just had a data privacy legal hackathon that went very well. And our next event will actually be on... Explore that issue, explore why it doesn't lend itself towards traditional regulatory methods, and then propose new solutions. I feel like someone's mocking me. Data privacy, that was great. We did it in 3 venues. In New York, San Francisco.
Is watching the live stream.
Okay, so Judge or Jake, if you have headphones, please... if you could use those, we'd appreciate it. I'm not talking to fake people. They're actually here with us. Okay. So next event is going to be on the music synchronization right as it pertains to online video content and how publishers have recently used this right to take down content for even non-commercial videos that exist on YouTube, and we're going to talk about that and possible solutions to that problem. So let's get to our panel. We're going to be talking about crowdsourcing the law. Now, crowdsourcing obviously has been extremely important to our internet economy over the last decade or so, and I think we've learned a lot from the crowd. The success of companies like Wikipedia and Quora and other massive crowdsourced platforms show you just how good the information can be coming from the crowd, and thus the term the wisdom of the crowd, if you will. Not necessarily reliable information, but information nonetheless, and a lot of it. We'd like to take this concept and bring it to certain ventures that exist in the law and legal services. So with us today, we have the Honorable Amadeo Santosuoso, who's a judge for the Court of Appeals from Milan. We have Matt Hull and John Watkinson, co-founders of Docracy, and Jake Heller, who's founder and CEO of Casetext. So I don't want to say too much. We're a little bit behind schedule anyway, and I think a good place to start here is, what is crowdsourcing, really? What is crowdsourcing the law? And just by way of intro, just introduce yourselves and let us know how you're interacting with this concept and what you think of it, just as a general impression. So let's start across the pond with Judge Santosuoso. Judge, are you there?
Yes, sir. I am here. Good morning, and thank you for inviting me in this meeting. The idea of crowdsourcing law is linked with the project of the Archive House. I will focus my presentation, even though it is connected in a very particular way. So, the focus of my presentation is legal multilingualism. That is a problem that is very important, as you can understand. In Europe, in continental Europe, we have a lot of languages, and even for documents by the European Union, it is a problem. So, but in general terms, we can say that that the people every day is more connected, and the more people is connected, the more the problem of the use of different languages is higher. Because the course and parliament, of course, use their own national languages, but English can work for international communication, but if we enlarge the area of connected people and we improve the level of interpretability of legal systems and norms, we have to use different languages. So multilingualism in law, I would say, is unavoidable. On the other side, from the technical side, automatic translation is not affordable, is risky. It's risky because there are a lot of mistakes and misunderstandings. There are also new tools, more updated, but in any case, at least till now, I think that it is still necessary some basic human work connecting legal concepts. So, just a few words about what is this archive. ELST stands for Multi-Language Archive on the Law, Science and New Technologies. It is a project of the European Center for Law, Science and New Technology at the University of Pavia. AS brings together cases and materials, and each of them is considered as a piece of law and is linked to similar pieces, whatever the country it comes from, whatever the language. Every material is written in its original language, but it has a file card that is drafted in English and that allows the communication among many different documents and languages. And so each piece of law can be retrieved through keywords entered in English and our national languages. So the practical facets of the archive are very simple. AS offers the people the opportunity to know the existence of cases that they do not suspect. For instance, I work in Italy, and it's possible that a similar case exists in Japan or in China, or I am not able, in any case, to know even the existence of this case. And so, through this project or archive, I can get the basic information on the case, and this basic information is given in English, and I can have access to the material, to the original material in its own language. So, once a user starts a query, he can use whatever language. Whatever the user language, the system establishes connections in all languages that are used in the archive. So the connection between legal concepts is possible thanks to a multilingual thesaurus that is provided and implemented by a company that is called Pool Party, and we are working with these people very well till now. So, very shortly, the theoretical background. In the lower part of this slide, you can see some references, but the main concept is that law nowadays is fragmented in space and time, is not hierarchically organized, at least in a stable way. It is not necessarily directional in the sense that spontaneous developments are every day more important than the intention of the lawmakers and so on. In the general legal scenario worldwide, there are a lot of different actors in this very technologized global environment. And so, according to the philosophy of the archive house, legal international and transnational experience looks like an immense web no? Ever-changing and connected. So this is the last slide. Of course, we have some critical aspects. Us is still a prototype, and it is not accessible yet on the web, because we have decided to open it once we have reached a critical mass of information in order to have the, let's say, regular functioning of the archive. On the other side, the archive, this project of archive, implies the existence of international cooperative groups of people that work in a networked way. Just to make an example, we have materials and cases on neuroscience and law, because we as a group in Pavia, at University of Pavia, are very active and we have a position of leadership in the international landscape of neuroscience and law. So there is a group of people already working in this area, and then we can propose them to share this tool. And other fields are fields of robotics and law, privacy, and others. But of course, this is very expensive, because when you have to have people that have to work in this area, it takes time and funds are necessary. The alternative is a wiki development. But I have to be sincere, I am a little bit reluctant, because I am afraid that the level of accuracy of the translation from national languages into English as local language perhaps wouldn't be so good. So I hope in a reasonable time to have the possibility to show the archive, even though in a still embryonic form. Thank you. Thank you very much.
Thank you very much, Judge. Now, Jake, before you go, we are going to have to disconnect the call so that we can share the screen. So we're going to hang up on you. I'm sorry. And then we'll call you right back, okay?
Okay.
In the meantime, I think the judge raises an important point here, and maybe a major obstacle to crowdsourcing the law. So the beauty of crowdsourcing information in general is that you just get a ton of it. The thing about the law is that it's very important, and that language is very important. So I know that some have discussed, I know I've at least thought about the possibility of crowdsourcing law in a very real sense, right? We're all collectively drafting legislation. That becomes a problem when language is such a huge factor here. And I'd like to put a pin in that issue, perhaps, because one issue that we're seeing here in the States when trying to parse out statutory text, for instance, is that there's no standard form for publishing statutory text online. Many have resorted to XML, for instance, as a good markup language, standard markup language for that text. But that's not uniform, and no state is required to release their statutory text in that form. So we see issues in that sort of collective standard issue. Jake, do we have you back now?
I believe we do. You guys hear me?
Great, yeah. So please, Jake, please introduce yourself and let us know what you're working on.
Sounds good. Hey, Bleak, do you want to hear me?
Yep.
Awesome. Okay, so I'm Jake Keller. I'm the founder and CEO of a company called CaseText. And I think I'd like to start by touching on the questions that Phil raised. What is crowdsourcing? How does it apply to the law? And I think that a little bit of background and context really helps here. So before the internet, if any of you can remember that, we all used to get our information in one way. It was through books. We would essentially get information disseminated by experts to people who would buy it. And the result of that kind of processes of disseminating information in a one-way conversation was kind of twofold. The first is that it's expensive, right? I'm Jake Keller. I'm the it's just kind of broken with a bit of audio. Is that are we coming through clear?
Yeah.
Yes.
Okay, awesome. So the kind of results are twofold. The first result is that it was expensive, right? It was controlled by the few people from whom you must purchase the information, right? So you have Encarta and Britannica, and back in the day, I still have shelves and shelves of CD-ROMs, CD-plays, books of encyclopedias. And the second problem is that it was based on a small cabal of self-appointed experts, or not even self-appointed. Sometimes they're widely recognized experts. There's no diversity in the opinions that were being shared. Organically, what we saw is the old model was displaced organically by the web. Web technology appeared, and these things just popped up out of nowhere without almost any thought. It just happened. So Encarta and Britannica were displaced by Wikipedia in the very early ages of the web. Software which was written by the experts at IBM and Microsoft, for example, was there's still kind of an ongoing process here, but it went from a kind of one-way, you write the software, you use it, to open source software that people collectively put together, to entire operating systems like Linux being written by a group of people, code being shared on sites like GitHub. And kind of a more social aspect of it, I don't go to a restaurant today without checking Yelp. I don't, nobody goes to Zagat anymore. Maybe they do, maybe, through Google, but, I don't go, and I live in California. Traffic is a big issue for us. I don't drive now without checking Waze, and nobody uses the Tele-Atlas traffic information. Probably not even heard of Tele-Atlas before. And it's that these crowds have done so much better than this information coming one unidirectionally from the experts. The benefits of this approach so far have been that it's free. You have free open source software, a free Wikipedia, and even more interesting, in my opinion, is that the quality of the information has over time evolved to be better. So Wikipedia they've actually done studies on this. They've proved scientifically, no, not scientifically, sorry, on scientific articles, they proved that the Wikipedia articles were on the whole more accurate than what you get in encyclopedias like Encarta and Britannica. And I mean, just from personal experience, the aggregate star rating of a Yelp restaurant far better predicts my, likelihood of liking the restaurant than what a single person or even a group of people at a company like Zagat thinks. So that's what that's the kind of world I grew up on. I grew up in Silicon Valley. I saw this happening, and I was excited by it. And then I went into law. And the first thing you do when you get to law school, one of the first things I did was you get quickly introduced to legal research platforms, which to a lot of people I think are a vast improvement. They're a vast improvement on reading it in books, in the sense that you can now search through it, sort your search results, save your own personal notes, and so on. But in a very real sense, it's not very different than what legal research was like. Getting information through legal research is like through books. You get information from a single group of experts who write the head notes, the case summaries, do shepherds, and it's just like what it was when it's books. It's very expensive. It's a one-way conversation that you pay a lot of money for, and in that respect, legal research has for a very long time reminded me what it of pre-web technology. So I'd like to share with you what I started in order to kind of counterbalance that. And I'm curious, can you guys see my screen?
Yes.
All right, so this is case text. This is the thing I've been working on for the last 9 or so months.
Wait, we cannot see your screen. Sorry.
Oh, you cannot see it. Okay. What about now?
Yes.
Got it.
Awesome. Great. All right. So this is case text. It's available at casetext.com. The whole idea behind case text is we can build something for free that is a step ahead in legal research. That as a community of people working together, we can build something more interesting than what you can get for paying literally millions of dollars. And that's the basic premise, right? And kind of like as the homepage says, legal research on the shoulders of giants. The idea is why not do legal research if you can have it benefited by the annotations, thoughts, and notes of some of the leading experts in the field. And I'll get into it in probably So the community is just getting off the ground, but I think there's some pretty exciting early results, especially on some of the biggest cases. Like Ashcroft and Iqbal, for all you law students who haven't come across the civil procedure yet, you will come across it. And one of the things that's really cool, I mean, so we have such things as like a quick back section at the top that includes a holding and a summary. All this is written by the community. You can expand it out and read, kind of a big picture background of the case before you jump into the text itself. But one of the things really cool is we have a person named Professor Alex Reinhardt. He's kind of down the road. He's in Cordova University. And what I think is really cool about this annotation in particular is this is the guy who argued the case on behalf of Iqbal. And he's also a professor. And the combination of the two means he's been studying this case, and he lost. So he's been studying this case very intensely since since the time he's argued it, even from before when he argued it. He spent a lot of time studying on it. And you guys may recognize from sites like Quora or Reddit, there's upvoting and downvoting systems to sort the best stuff at the top. This is by far the most upvoted thing on the website right now, in part because you have an expert who is thought intensely about this process, this issue, and it's pinpointed the paragraph of the case that has to do with the that explains how judges have been confused going forward ever since Iqbal's lost it. Other small cool things. In other big cases, we are kind of lucky to have we have a working relationship with a lot of the biggest firms, and they have like this they publish so much information about cases as they come out. They have this intense need and desire for people to read their stuff because what they want more than anything else is for them to be viewed as the leader in X or Y field, like in IT. And so they've kind of happily integrated a lot of their content into case text. And what's cool about this is when you're doing research on case text, firms have written about in the recent past and still integrate a lot of this content. You can read an entire case summary and analysis right there at the top of the case. And again, this is all 100% for free for us and for the world. And what I think is cool about it is this section over here. I don't know if you guys can read it on the screen. I can only imagine it's kind of small. But you have this thing that says implications, right? And that doesn't happen when you pay millions of dollars for a case summary. They just kind of rotely describe the posture, the holding. But the incentives here are aligned in such a way that the authors of these articles want to actually take you a step further. They're trying to prove to potential clients, potential people they may want to hire, that they're on top of their stuff. Two quick final examples. The one is that this actually helps quite a lot during search. So we have worked with a number of directors of law libraries and the law librarians and legal research experts that are involved in this project from the beginning, which is fun and awesome. One of the proposals we got was from this professor named Richard Leiter at Scribbner's University of Nebraska. And he said, there are only some cases that have been studied very intensely in secondary literature. Why not make a filter that you can narrow your search to only those cases that have been cited extensively in secondary literature? We call this the leading cases filter. So you can add tags to any case you want to make your own search filters. People have been doing this. You can see them kind of running along the right side. It's a little ugly right now, but we'll fix that. But one example of the leading cases filter in action, you can search for a word like patent, and you get 46,616 cases back. And you're like, well, maybe I only want to see U.S. Supreme Court cases about patents. It's still 3,500 cases, which is way too many. And that's the kind of the typical research experience you have when you're doing research on some of the bigger products. What's neat is you can click the leading cases filter, and now of the 3,500, the 400 that have been discussed extensively in the Supreme Court that are leading cases kind of pop up immediately. And then you say, well, I want to only see the things that I or somebody else has tagged innovation. And now we're down to the two cases that deal with patents, innovation, and leading cases. And I think that's a kind of a neat way that collective tagging can make the search experience much better. Final thing we'll cover is something that actually happened at Brooklyn Law School, believe it or not. One of the things we've been doing is a project called Reset. And this is our most recent big push is to get a kind of a form of shepherds that is done instead of by individual, quote-unquote expert at Lexis or Westlaw. We have a community of people actively, moderated, of course, by a cadre of legal, I think a lot of our communities are extremely involved. But the initial effort has been done in people's homes and in classrooms across the country. And this is the case that was cited by a group of lawsuits, who I even recognize these names. What's cool about this is, instead of just having a flag, what you get to have instead are the actual typed out descriptions of how two cases relate to each other. Because that's what you get with the power of the crowd. People can describe the relationship between two cases. And they market that these are distinguished positively or negatively affecting a case. These elements get distinguishing treatment. And then it's sorted by votes, again, to signify what should be read first. And so, this one, by 20 people who come across the case Grant Home Field, has voted this as the most important distinguishing case it could be. We also, of course, do newest to oldest, or only positive. Point being that you can kind of get really in depth into the relationship between cases. And again, because it's all being done by a community, this is all for free. And so I think this is I'm very excited to look in the field. There's a lot more we can be doing to add to this. But what we're trying to do is the very budding beginning of a movement to make the law and the understanding of law free.
Great, thank you so much, Jake. And so last and certainly not least, we have John Watkinson and Matt Hall from Docracy. We've gotten perspectives on crowdsourced legal citation and crowdsourced legal principles across nationalities. Finally, I think these guys represent crowdsourced, I guess, consumer law, because we're talking about contracts, right? We're talking about crowdsourced contracts, and for all intents and purposes becomes law. And they wanted to show you a little bit of Docracy, and I'll let them take it away.
Hi, thank you. As Phil said, we represent sort of the other end of the spectrum. If these are sort of crowds in the expert sense, we're sort of mob rule. Anybody can participate in our site, and that's sort of the point in some sense. So we're just going to give you just sort of a look at what the site is, just briefly, so you can understand sort of our... I keep talking. I'm going to stretch it out. Take a little time here. And when we started, it was sort of the idea was that there's no place for this. Basically, Docracy is a repository of contracts, and they can come from anyone. They can come from a lawyer, from a person from like an idiot. Anyone can upload these things. So the idea originally was met with a fair amount of skepticism. These are not the kind of thing that you should be uploading and then going and downloading just with no real idea of what you're doing. But what was sort of touched on in the Shake Law presentation is there's this vast bulk of low low danger transactions that go on out there, where kind of understanding your counterparty is most of the benefit of doing those contracts. So. And people were potentially not even getting that from legal help, even if they were willing to pay for it. That what they wanted was just to be able, both parties, to understand what they were agreeing to. So that was our idea, and what we wanted to do was sort of test that, the feasibility of that as quickly as possible. So one, would anyone contribute a legal document? What kind of person would do that? And two, would anyone trust it enough to download it? So we'll give you just an idea. We're a fair ways into this now. We're a few years into it. So the contracts on our site are kind of all over Google now. Search engine optimization is a pretty long game, but we're getting there. So we'll start by giving you a search. So like an independent contractor agreement is one of the more popular contracts on our site, and kind of hits the meat of what people use the site for. So if you search for it, we're the first result for that now. And this is a contract that, if we click on it, has been contributed by a lawyer. And you'll see this is basically what the point of the site is to provide, first of all, the full text of the document, so there's no kind of sneaky stuff. We're not a document builder in that sense. You don't piece things together. We give you the whole thing. It represents a coherent viewpoint, like a person who does this, here's what I recommend, stuff like that. So what we focus on is basically letting you customize it in those few ways that you'd want to: values, dates, names, things like that. And what we do is we simply track the usage of this document. We track who it's from and how it's used, and then let you decide beyond that. So this one is from a lawyer, and you can see on the right side we track a whole bunch of stuff, stats about the lawyer. We track views of the documents. This document's been viewed 237,000 times. It's been downloaded almost 1,500 times. It's been saved by somebody 250, and it's been signed 106 times. So, then signing is sort of the second phase of this, which I'll just touch on. We won't give you a full look at that. So the interesting thing about the platform, one, is you can contribute these documents and get them. So that's, from a consumer point of view, that's what they're looking for. But sort of the trick that we've done here is that we can allow you to edit these documents on the site, customize them for your needs, and contribute it back to the community, and we track sort of the heritage of that document. So if you look down here in related documents, you can see a few things that are basically based on this document and have been changed by somebody else. And you don't really know until you click through what the details are there, but we'll pick one here. And this is for, basically it looks like it's been modified for development, so like software purposes. And since we know what the original document was, we can show you the changes. We can generate a red line, basically. So we use so we're both basically developers. So this is natural for us to take a look at what changed in software, and we thought it made sense to do here. So we've done a version of that for this.
Wait, you're not lawyers?
We're not lawyers. We've been to a bunch of these conferences, so we're pretty much lawyers, like you guys. Are we getting an honorary degree? Does that happen at this? We speak at graduation. So we'll probably speak at graduation. I accept your invitation. Thank you so much. And we'll get a quick honorary degree. And then we'll be lawyers. So, but right now, not lawyers. That's true. We don't know anything about this. For us, this is sort of like a black box. Like, there's data and there's information, and we'll track information about it, but you're the consumer of this. You decide, and people who produce it, like, is that person someone trustworthy, and so on. So here's the red line. Here's of that document. And over time, what's happening is that these sort of, canonical basic documents, things like an independent contractor agreement, are getting customized for this long tail of uses and being contributed back. So you can find something that's very close to what you're trying to do exactly, rather than having it be customized. So the document corpus is sort of growing over time and becoming more and more specific. So, and the second phase of what we've done with this is we've taken this and we've added signing. So you can do the full transaction within the confines of this system. So you know where the document came from, and you know who you're signing it with, and you know how you have changed it versus this original document. So the idea is that you can make this transaction so much simpler for someone you don't know that well. Let's just use the thing that everybody uses, Ondocracy, and I know you haven't messed with it because I can see that you haven't made any changes. So that's sort of the full picture as the site stands now. I think that's sort of it.
Just this handsome gentleman here is our mascot.
Oh, Eric, put up your hand over there. Look at how this is our homepage from our site, and Eric's been there for I think a year now, and look at how hard he's working. See, he could work like that hard for you. So that's a bunch of we make lawyers look great on the site. So if you have documents, you should put them up. We have these pretty cool profiles for lawyers. That's it.
Thank you, guys. So we only have about 20 minutes left, but I think there are a few questions I'd like to pose to all of our panelists, and then maybe open it up for a few questions from the audience. But I think the first question is, we've heard about legal citation, we've heard about crowdsourcing the drafting of legal documents like contracts, we've heard about crowdsourcing legal principles across nationalities. What are some other areas of law or legal practice that, based on your experience, really lend themselves to this kind of crowdsourced model in any fashion? And I throw that out to anyone who's willing to take that. Perhaps Jake?
Sure, yeah, happy to. This is a little more out there, but some people talk about crowdsourcing laws themselves, or at least the drafts of laws. One of the challenges you have pre-technology is when you're trying to propose a bill to Congress, even for interest groups, you have to hire a representative or a lobbyist, be it as it may, to write the bill that you propose to Congress. You want them to pass on your behalf, and it never fully captured the full views of the community that was representing. And I think that there are kind of interesting opportunities if the system set up right, hey, probably can't work if you get really editing everything. But it could maybe have a situation where the views of the community were taken very, deeply in the drafting of the laws themselves. And I think democracy is actually a big step in that direction. As you mentioned, Phil, introducing them, private law becomes the law, so to speak, because it binds the two parties. And it's not that big of a step to even a bigger, push towards having the laws themselves being, at least the initial drafting of it being crowdsourced in some fashion. I think that's kind of cool.
I mean, obviously, you guys, well, you described it at one point as GitHub for legal documents, right? So,
That's right.
So Matt, John, what do you think about? Have you taken a look at the crowdsourcing statutory text efforts and legal documents efforts on GitHub? What do you think of those? How do they differ from your efforts? Where can we go next?
Yeah, I mean, obviously we've focused more on sort of consumer law, and the things that we find really popular are sort of freelancer, and then a lot of individual law, even stuff that's sort of almost like form letter, like barely even legal, like things like a 30-day move-out notice or a friendly collection letter, like that stuff's popular. But when we thought about where could it go, and obviously you could be drafting entire legislation on there, something like that. I mean, we shied away from that just because we needed focus, and we had a big job ahead of us just with what we were doing. But some of that's happened, and because GitHub is sort of like the mascot of open source, a lot of it's happened there. We think that our diffing is much sort of more English friendly. Like if you're trying to read English text or legal text, we have a lot of smart diffing for that. Whereas GitHub is more programmer line based diffing. So we're always a little sometimes there was in the wake of, say, like Instagram's privacy policy change, and people got mad about it. There was some of that stuff was like, Tumblr or whatever. We posted ours to GitHub, so you can see every change we're making, and we were sort of like, come on, man, that's democracy, because we do such nice diffing of that kind of stuff. So you can really, look, they changed that, that word, or they changed, that phrase to that phrase, and GitHub's not quite as convenient for that. But obviously, you get the same result. Everyone can see exactly what changed, and there's no reason why that stuff shouldn't happen.
Sure. And just to get the other side of the story here, Judge, perhaps you'd like to talk about this. I mean, what do you guys see as the biggest hurdles to crowdsourcing legal services? I mean, this is typically a pretty buttoned up private service. It's between two people for the most part, and a lot of lawyers don't like to divulge their secret sauce at all. What are some of the hurdles to putting legal advice, law out there for the public to read, comment on, state their opinion on? What are the obstacles here? Judge, perhaps you'd like to talk about this from the language perspective you were talking about earlier.
I'm not sure you still have it.
Okay, so Jake, Matt, John?
Yeah, I'd be happy to touch on that.
Yeah, sure.
I mean, starting a community-based website is always going to be a challenge at the very beginning. A lot of people are like, why? Why would I participate? And it's more true than ever with lawyers. What you see happen is lawyers are really, really good these days at publishing some bits of information very extensively. And that bit of information is, here's a summary of a case that just happened. Here's, I should say, first and foremost, client alerts and blogs, right? So lawyers and professors extensively write blogs and client alerts and client memos, and they're happy to have that read by literally everyone. I think the history behind this, for what it's worth, is kind of interesting. Mark Lipton in the late 70s published an article divulging exactly how he approached something called the poison pill. And people, I think, at the time were like, you're crazy. How could you be divulging this like amazing strategy to protect your clients and not others? And his response was, I'm going to get all the business. I'm going to prove to the world that I'm the guy you should be talking to if you want to think about these kind of issues. I've literally written the book. And so that kind of information, in a crass sense, basically for marketing, right? You get a lot of that. What you're never going to see online, hopefully, is people dealing with what should be a one-on-one client issue in a crowdsourced fashion. I think it's actually dangerous. You don't, there are ethical rules here. You don't want to divulge client secrets to the entire world because you're collaborating on an open platform. So there are things that make sense to crowdsource and things that kind of don't. There are places where the incentives align and places. I mean, I can check out Docracy, for example. Their pages to a lawyer or a law firm that show the contracts you work on. I think it's exactly why a lot of lawyers are contributing. Because they get to show the world, you guys can correct me if I'm wrong about this, they get to show the world, like, look at me, I am really awesome at this area of contract law. If you want the real deal, you got to hire us, but we're going to give you this bit to prove to you how good we are at drafting, negotiating, coming up with contract language.
Does that ring true with you guys? Do you think the marketing prospects of your platform create a good incentive to create good content?
Yeah, I think so. I mean, that sort of was our pitch to lawyers, is that this is a way to get your name out there as an expert in a certain area. Obviously, don't give away the whole farm. Is that a saying? It's not really a saying. It is now. So, and but the sort of the initial stuff, the stuff that you would probably do for low amounts of money, that might be worth it in the sense that, like, this sort of machine for people finding contracts, pointing to contracts, is exactly what Google's looking for. They're looking for the world of links to point them to the best content, and that seems to be happening on the site. So it's a worthwhile trade-off, I think. And I think that for us, like, some of the risks and stuff are on this continuum where there's things that are fine to do with this, right? There's like some, like what John mentioned, 30-day, move-out notice, things like that. And a contract for $500 to do a website, fine. But as you start moving up sort of the risk levels and continuum, then that's when you want to get in touch with the person who might have drafted the contract you've been using for the cheap stuff and say, like, actually it's starting to get serious. Like, I think we're pretty upfront about that this isn't for everything, but it is for this whole like sort of bulk of like really like not super interesting work to lawyers, but is sort of like this, a bulk of this kind of low-end transaction stuff.
And we had a law firm that specializes in sort of startup technology company work, and they said they wanted all their sort of initial set of documents that they would normally give their clients. They wanted those out there because if they'd kind of take a loss on that work anyway. That really early work they do for a startup, that's just sort of like placing a bet that eventually they'll get some really lucrative work from them as they succeed. So they would rather them come in the door a little later, maybe having not engaged them yet, but having used all their documents, so then they don't have this nasty cleanup process to get things started. And then, it helps market them as well and make them look good to the community. So we have had that kind of stuff happening.
Have you ever come across the situation where you've got a non-lawyer who's beating out one of your giant law firms on your site for their documents, and how do they respond to that?
Yeah, we have a sort of a funny example of that, which is one, and a good example. The funny example is that one of John's contracts, which was just like something we uploaded from our company when we started the site, just because it was so early that it just kind of ended up getting used by a bunch of stuff, and then when like lawyers we knew looked at it, they're like, that thing's not that good, you know that, right? And we're like, yeah, we kind of know it now, but you should like write on there, like, this is part of the thing too, is like say on the contract it's not that good. That's fine with us, like, but
yeah, there's like a discussion section, yeah.
Yeah, so then it was like, people started pointing to some of the better stuff. It was an NDA, so now that thing's finally dropped off. So the process is working a little bit. Like there's a bunch of this happening off-site too, which is the good example that in the design community, like sort of on like web designers and sort of creative professional people, they have some sort of, I would say like sort of community leader type people who post stuff on their blog, like here's how I run my business and stuff like that. And they started posting their contracts to the site. And the contracts are fairly different than the kind of boilerplate you would get from a lawyer. And they're missing a bunch of stuff. And they were saying that, basically I didn't understand it, and my clients didn't understand it, and it led to this long back and forth, and it was expensive for both of us, and it was kind of unpleasant. So I've been using this contract for 10 years. It's missing this stuff. Some of it's a little risky, but it's worth it for me for this relationship. And so there was a discussion of that. So that's a pretty popular document because, and some lawyers don't like it, but it's been brought in by a big community. It's pointed to by them, so it's ended up being pretty popular.
All right, with that, I think we can open it up for a few questions. We got about 5 minutes left. So if anyone has questions for our panelists.
Is anyone as scared as I was 4 years ago when I heard about Docracy, and 2 years ago when I heard about Shake Law, and this year when I heard about Case Text? I think, these guys are good salesmen. They tried to make us part of their process. bring us in. But is there a problem that that this is the first domino in the destruction of legal services?
I think there's that fear of this is going to lead to self-lawyering, and that which might hurt lawyers' business as well as hurt these clients. But I think you have to give people more credit, than that. Like the sense we get from our users and everything is that they sort of know when they're in too deep, and they know when they need help, and so this is, there was already this sort of Sheikh was. Vinay was referring that there's already this self-learning going on at the low level, and you can't really change that. I think it makes sense to sort of embrace that, know it's happening, allow it to happen, and then do what you're best at as lawyers, which is the important stuff. And that's not going anywhere. The mechanization of law, that's a hard process. This is like subtle text that needs to be interpreted when it gets serious. So.
Yeah, two quick thoughts similarly. First, a lot of people, I think, it's funny, the history of technology here. When Excel came out, people were like, count it, they're done. What are they going to do all day? They can't build for 8 more hours because they're not going to spend all the time for paper adding up columns. And what ended up happening is they were doing much more complicated, in the case of Admiral, kind of terrible things. But most of it was just like transferred to kind of high impact, high intelligence work. And move in that direction. The second thing I would say is on our website, and I think this is true of Oxygen. I should mention also Buddhist, and they're really awesome. The Buddhist.com, really awesome kind of crowdsourced legal research site. It's all about empowering the lawyer. And for me, that feeling of researching alone, that I show up at a Westlaw page and be like, I know thousands of people look at this and talk about this, and I'm no better for that, for that collective effort. But I think it empowers the lawyer that's doing research. That's not disempowered. They get to see what professors, law firms, etc. think about the stuff that you're working on. Hopefully elevate the profession, but destroy it. That's the hope, anyways.
So the way I like to look at it is you sort of have disrupted and disintermediated the work that was essentially largely done by paralegals, secretaries, and first, sometimes second-year associates. It's the grunt work that you didn't want to do. It's the stuff that the internet could do for you now, and it frees up the lawyers to use their bona fide training that they got in law school to do that subtle, nuanced analysis that the internet can't do. For me, this is verification that law as a profession will survive without the nonsense of the early work. We'll be brought in after the fact, I think, to do what we were trained to do, and what justifies a $500 an hour salary.
Thanks. Hi, guys. I think it's a great product, actually. I think all of these products that help people who otherwise wouldn't get contracts and would sort of wing it or not go see attorneys, I think that's just a step in the right direction. But I've been hearing things across the morning, and some of them I agree with for the most part, but some of them it's not that I don't agree with, but I think they're sort of mischaracterized. And I think the main one is sort of the thinking that we're giving away our quote-unquote secret sauce. The reality is that lawyers are sort of hired guns. You have to go in and you have to fight for a position. And there's some contracts that when we put on websites with our name, we attach ourselves to things that may hurt our clients down the line. For example, if you go and you're acting for a purchaser and you put up a purchase agreement, as a purchaser, you can understand that you're going to be fighting for things like indemnifications that are like 50%. But you're going to have to turn around the next week and fight for a vendor, or you're going to be asking for something that's like really a fraction of that. And opposing counsel for the next 5 years is going to be pointing at something with your picture next to it that says the opposite. So I think for certain things, it's not even a question of not wanting to divulge your secrets, but I think there are certain types of contracts that just don't lend themselves well to that. And I think one of the second and last point, I know other people will have things to say, but I like the idea, even if contracts are small, I think we sometimes tend to attach smallness to monetary value, to the thinking that, oh, this is just $500, it doesn't matter. But the reality is that sometimes that $500 can be $500 of somebody, paying for something, let's say like viral open source software that they go on to build something huge for that they then can't commercialize. So, it can have implications down the line. And one of the things that I do really like is, for example, a source like, I'm throwing it out there, but like Practical Law, which I know is not very hip. It's a Thomas Reuther product. But the thinking of having some kind of checklist for products that people can sort of rely on to decide if a product is for them or not is, I think for me, it's always sort of worked really well. Not for little things, but maybe for some of the bigger contracts, broader implications like software license agreements.
So, Matt and John, do you know if anyone is using multiple presences, multiple personalities on Docracy to present two conflicting points of view so that they can be the hired gun for multiple sides?
I don't know. We don't know specifically if they're doing that or not, but it sounds like a great strategy now. Like, oh, here's a standard purchasing agreement, and it stinks.
We'll check our IP address logs. Yeah.
Yeah.
Yeah. And I think you're right about that. And I think we source from different members of the community, so that might be something where that actually comes from. Maybe a general counsel who does, who only represents one side of that ever, or something like that. On the topic of the so-called small stuff, where it's like that it might not be small, it might turn big. I think I guess our argument there is that no matter what, it's literally not in the budget of that project to get a lawyer. So yeah, maybe there's other tools, but there has to be something inexpensive there. Because it's just not in the budget, even if you believe it's going to be huge, maybe you're willing to go out on a limb. But for tons of this stuff, it's just not even a possibility to engage a lawyer for small stuff like that. So there has to be something, obviously before these existed, the answer was most people and a lot of people who use Docracy said that prior to this they just didn't have a contract. Just all right, I'll do it for you. How much? Good, handshake. So that's where they were coming from.
We had a question back here.
It's more of a thought. I haven't quite developed it, but you mentioned how we're sort of getting rid of the paralegal work and the stuff that young associates do and getting to the real meat of it. But I think there's a value in the training of doing that stuff as a young lawyer. And I think my concern is that the technology for practice and for crowdsourcing is not is accelerating much faster than the legal education, because I know as someone who graduated from law school recently, there's really no practical training that you get except in clinics to be a lawyer. It's all case law and things like that, and things like case text are great as a resource, but there's it's a little too easy to go on and find someone else's NDA, someone else's independent contractor agreement, and not really work out what it is you're working on as a lawyer. I think there's like I said, I don't know what a question is, but I'm wondering what concerns you have as people who are developing these tools to make sort of people aren't sort of breezing by with these documents.
I guess the question is that work more like Excel, in that it's something Excel replaced, in that it's replacing the kind of work that nobody really wants to do anymore, and nobody does it anymore. I don't know, but I've seen an accounting school. You don't start by taking off like a piece of paper and start adding up the columns yourself, right? Or is it kind of get you all the training? Actually, I don't know the answer to that. I think in the context of litigation, I'm an ex-litigator. That's the context that I bring to it. I agree with you that the real training you get through the clinics and in real life, but starting from an elevated position, from where you get to see what diversity of viewpoints says about a particular case or a set of cases, what the leading firms in the industry think the implications are. I think that could be your jumping off point for your analysis, and start to kind of push you the starting point forward. And it helps you develop your own thoughts and see what the people who've been practicing the area for some cases, decades, think themselves. So I think it's upside. But there are serious questions, I think, and you're right. How much of the fundamentals should you have to do to really learn? And it's a question for law schools, right? Should law schools, in a world where crowdsourcing and the looking kind of approach, displaces a lot of information, a lot of the groundwork, should law schools teach the fundamentals and get people to understand the true basics before they go out into the world where a lot of that breaks down for them? I think it's a good question.
Yeah, to me, it sounds like the legal profession's corollary to the article a few months ago is Google making us stupid. And I don't think Google is making us stupid. I think Google is giving us the tools to actually apply the knowledge that we don't need to have, but apply it with wisdom. And I mean, I look at this like the internet is very good at one thing, separating black and white ones and zeros, but has no ability to work in the subtle nuances, and that's where your legal training comes in. So if you can get a jump start, I spent 2 years, I wasted 2 years at a law firm doing nothing but things like discovery and document production, and these were not the legal skills. I could have accelerated. You're right, there is some value in spending a little bit of time getting some affinity with the documents, but spending 2 years mired in discovery or mired in document production, I don't think is time well served for a burgeoning, sophisticated attorney.
If I can make one final point, I think these ventures are extremely inspiring from a practical perspective. I work at a 3-man firm in Soho. We work mostly with digital contracts, and I'm active on Docracy. I use Docracy all the time to find samples of contracts that I know nothing about, just a starting point, which is a common practice in law. And I think it's also inspiring that these ventures are made by 1, 2, 3-man teams. When I'm on a 3-man team, and I can maybe bring on one more person who could make these tools for us in-house and provide those to our clients directly, perhaps. And I think that's going to be a model for these bootstrapped firms going forward, and something we're going to see a lot more of. So that's my final note. I think that's it. Thank you, everyone.
I'm sorry. No, there are a couple more questions. We'll have time. Folks will be around. We will, as the day progresses, get more interactive with you all. But we've got a special guest now. Is Ben Kalos here? Where is he? Ben, why don't you come down? We've asked Ben to be relatively brief, but I've known Ben for several years. He's an attorney. He is also one of the most knowledgeable technology-oriented attorneys it's been my pleasure to know. He's worked with a lot of civic technology issues. He's sort of a pioneer. We are fortunate, I think, in New York to have him as a new member of the City Council and the chair of the Government Ops Committee. So I think New York is one of the few cities in the country and the world fortunate enough to have a city council person who actually knows technology, knows how to harness technology for civic value.
Can everybody hear me? Thank you. I'm Ben Kalos. That's at Ben Kalos on Twitter. I will be one of your first speakers who will actually be offended if you do not have your phones or laptops out and aren't live tweeting what we're saying. I'll be checking up there to make sure that it's getting out there into this Twitter sphere so that those who can't be here can also participate. I want to thank Jonathan Askin for having me here and for all that he has been doing. I'm a lawyer. I'm a free, Libre, and open source software developer. I'm former in-house counsel for a venture vehicle that ran a tech startup in California, and I'm one of your New York City Council members. I'm here to speak about hacking the law. By way of background, I run a small business. It has a $70 billion annual budget with 350,000 employees. It's the largest market force in the United States after the federal government, the New York State government, and the California government. So when you think about that, that is the power that we have to harness. I'm on day 94 on the job. I have 3 years, 8 months, and 26 days to go. Hack your time. Time is precious. Use your time to benefit as many people as possible as you can on this planet. When you do something small, make it reusable and scalable. You'll be able to use it again, and it may start small, but it can be big. I went to SUNY Buffalo Law School, and most of you may know who are lawyers. You're not actually really taught the law. You're taught how to think. And so I would say hack law school. Learn how to think. Be agile. Be iterative. Test your learning in a safe environment. Get as much real-world experience as possible. Join Dr. Askin's Blip Clinic. And if you're already in practice, volunteer pro bono. It's a great place to test your theories. You've learned how to think. You've passed the bar. Now you're a lawyer. Lawyers are essentially logic and reasoning engines. Many of our tasks can be delegated to second-year associates, paralegals, secretaries, but more often than not, they can be delegated to software and automated. I was an ERISA litigation attorney. I had to deal with fact patterns involving 300 individuals and claims that that were on a monthly basis over 6 years, compounding daily. The documents I filed were large and thousands of claims, hundreds of pages, and instead of spending 400, 800, 1,600 hours on a case, I was able to automate the entire process, and I was able to get through several dozen federal cases, several hundred state cases, several thousand civil cases in about 3 years of practice. In so doing, you can automate the parts of the job you hate and spend 80%, and that which would usually take 80% of your time would be automated, and the 20% of the job that you should be making those big dollars for, you can focus on. It usually tends to be the part of the job you like the most, and you can spend 100% of your time on it. Learn the common language, not legalize, but the common language, even slang. Whether you're a developer, quant, or lawyer, using vocabulary no one else understands can be useful in sharing large quantities of information quickly, but to everyone else, it's a waste of time. Using plain language that anyone can understand is essential, and we need to do our part to help there. We're all governed by law, and yet no one knows it. Can anyone honestly say that they have memorized the U.S. Constitution, the New York State Constitution, the New York City Charter? Anybody? So we're governed by these laws, and so in 2006 I launched wikilaw.org. It's since been merged with jurispedia.org. When Google launched its Scholar project, it was one of the last legal websites that really survived that, because what we were focused on wasn't on getting the law online per se, but actually making it understandable. So the first step of hacking the law is make it understandable. You can start by writing law journal articles to explain for your colleagues. Yes, fellow attorneys who are theoretically experts don't understand the law. We go to law journal articles, and if you are a subject matter expert, when attorneys are looking for somebody to hire, they will tend to try to hire somebody who has all the law journal publications on the issue that matters. It's very similar to how the open source community. You can also help laymen. You can write articles for Wikipedia, blogs, whatever you need to do in order to make the law more accessible to people, but it is the challenge that's forthcoming for our generation. Now, one of the reasons I'm here is to share that the law is not immutable. Just sit with that for a moment. So many people think the law is the law and it's not really changing and we're stuck with it. But we change the law every day. It is living and breathing. You don't need to go to the Supreme Court. Contracts are altering or waiving our rights under the law in exchange for consideration. The courts provide different interpretations of the law down to a county level. If you want to litigate a case in New York County, you may get a different outcome than in Brooklyn County. And then there's legislation, which is why I am here today. The first step in the right direction was in 1995 when Congress empowered the Library of Congress to create thomas.loc.gov, where they put the law online and legislation online for the first time. That wasn't too long ago. And now you can actually read and follow the legislative process. In 2007, we had the next step in the direction when Sunlight Foundation launched Open Congress, which is run by David Moore and Participatory Politics Foundation. And so for the first time, you could read, comment, and improve upon federal legislation. And so we started crowdsourcing it. But that really didn't help us on a very local level. In 2009, I launched openlegislation.org to get all of New York State's legislation and voting records online. And we did it so well that New York State and city legislators started doing it voluntarily. So here we are. It was myself, another developer, a team of two. We were able to create a Python scraper, get the law online, and the legislation online. And it took us, I'd say, about 10 hours over 6 months. And so with that little investment, you can have a catastrophic change in culture in Albany and New York City politics. So hack the law, take it back. In 2013, Sunlight Foundation launched Open States. With my developer and the code that we gave them, they've gone nationwide. So now we've made 50 state legislatures transparent. In 2013, I ran for city council. I crowdsourced my platform at kalosforcouncil.com. I started with 100 solutions, and we got 33 solutions from the community. People could vote on them, they could comment on them, they could improve upon them. It's on a Drupal 6 installation that I created and maintained. We also posted our platform to github.com/kalosforcouncil so that people could change our platform and do it in a way that many in the open source community might be comfortable with. Now everything's been moved over to our government site, benkalos.com. It's a Drupal 6 build that I maintain myself. I won, and now I'm in the city council. We're adopting broad sweeping reforms for putting our legislation online in a way that allows members of the community like you to comment and improve upon. We're demanding that vendors open up their APIs that host legislation so that you can do whatever you want with it without having to use a scraper as an intermediary. Most of my colleagues in government are not lawyers. Many bills are not drafted by lawyers. Sadly, many bills are still drafted by lobbyists who also may not be lawyers. I'm here to empower you, to ask you, to demand that you join me in hacking the law. Treat it like source code that instead of running your computer or your office suite, runs your government. When you run into a roadblock, ask where it's coming from. 99% of the roadblocks I faced in the past 94 days have gone away when I've asked, why not? Is it in the Constitution? Is it a law? Is it regulation? Is it a policy? Because anything short of the United States Constitution or the New York State Constitution, that's not an impediment that a legislator should be facing, because I'm here to make laws. Truly disruptive companies like Uber have been taking on the laws, getting them changed. As far as I know, I'm one of the only developers elected to office, and we need to make sure that the centuries-old laws do not stifle innovation. But we need you to hack the law so we can govern together and improve it. If you have an idea, draft model legislation, share it, organize support for it, get a legislator to pick it up, or if you're in a jurisdiction that has referendum, get it on the ballot. I'm here just to say, hack the law. This government belongs to you.
Thanks, Ben. I got to say, Ben is a genuine pioneer in this regard, but I'd like to think that 5, 10 years from now, a lot more of our representatives will look more like Ben. Maybe not a white man, but they'll look more in temperament like Ben.
Diversity of background and interest and skills.
I was reminded in 2007, one of the first cases that my students and I ever handled was representing a guy who was taking the MTA data sets and creating all sorts of wonderful applications out of it. Real-time travel information for the MTA. We got sued. Client got sued for copyright and trademark infringement. That was 6, 7 years ago. It's unheard of today, and it's in part because this state, this city, has recognized the need to make the information available to the citizens for better use of civic technology. So we're all set? All right. Good. Our next panel is on using technology for access to justice issues. Is that right? Is that where we're at? Good. I'm going to hand it over to Marcia Garrison. Where's Marcia? Great. Marcia is a professor at Brooklyn Law School who was inspired by her visit to The Hague and a project she submitted to The Hague about a year and a half ago. And we figured she was the appropriate person to try to discuss ways in which we could use innovative tools to improve access to justice. And are all the panelists here? Great. While they're setting up, I want to let folks know about the lunch that we're going to have. We're going up to the 10th floor for lunch, and this is going to be a real experiment in crowdsourcing the law. Okay. We are going to be trying to collaborate on building a citizens' charter for cyberspace. So we've already got the Declaration of Independence for Cyberspace that was coined a good 20 years ago. Actually, that was about the distance. No, I guess in 1776 we wrote the Declaration of Independence. About 11 years later, we wrote the Constitution. I'm looking at this in a similar vein. We've got the Declaration for Independence for Cyberspace, and now we, as the sophisticated attorneys and policy thinkers out there, are going to try to collaborate and figure out what it means to be a good citizen in the online universe and how we can make it a better experience for all of us as global citizens. Marcia.
Okay, we have a great group of panelists here with you today to talk about problems involving access to justice. As you've already gotten the sense from some of our earlier presentations, it's a large problem. My primary area of specialization, for example, is family law. There are many jurisdictions in the United States where as many of 90% of couples who obtain a divorce do so with no more than one lawyer. What does that one lawyer do? That lawyer, if they have one, and many of these couples are completely pro se, no lawyers at all, can only reduce the agreement that these couples have already reached to legal form. Increasingly, of course, those couples are not hiring that scrivener. They're going to something like LegalZoom to produce the document and thus getting no legal advice at all. What can legal innovation and technology do for divorcing couples, for people who have some kind of low-level dispute, the wide range of legal problems where people are not getting access to the legal community? That's what our panelists are going to talk to us about today, and we're going to start with Mark.
Great. I'm just going to make sure I can use the clicker.
Right click forward and left don't touch that one. This is right. This is moving forward.
Okay. And how do I get it onto the...
I'll come up for you.
Okay. Well, first of all, I want to thank Marcia and Jonathan and everyone here at Brooklyn Law School for actually including access to justice on the schedule today. I don't know, some of you may have, like me, gone to the reInvent Law Day recently at Cooper Union, and I was stunned at, I think there was one presenter during the entire day. They brought someone from the nonprofit sector, and I was really just stunned at how little consideration was given to the impact of these changing technologies on, access to justice issues. So I was really pleased that this was on here. I was a little curious and disappointed that the only sort of elected official in the room walked out right before we started our panel. But I know that he had, conflicting obligations.
He'll watch the webcast.
Right, he will, I'm sure. So before talking about the technology, and I'm Mark O'Brien, I'm the co-founder and executive director of Pro Bono Net, which is a national nonprofit based here in New York, which over the last 15 years has developed and supported web-based systems that are used pretty broadly by the public interest legal community, courts, and other justice actors to give capacity to the public interest legal community to address the needs of low-income people and other vulnerable communities. And before, I will show some technology and some examples of things that we've done, but I wanted to start by kind of thinking a little bit about how we define the problem. And so I put up a quote that comes from the Open Society Foundation's website about the concept of legal empowerment. And when we're thinking about what it is that technology uniquely enables us to think about in our approaches to using, to better serving the needs of all in our communities, there are a number of things in that quote that really jumped out at me. And one was that sort of focusing around this notion of capacity, what the capacity of individuals, and a lot of Pro Bono Net's work, and what I'll try and talk about in a quick jump through some different initiatives, is how we've rooted the work that we do in both an understanding and appreciation of new and evolving technologies, but also about what is the capacity within the communities of legal organizations, non-legal organizations, and others that we are trying to deploy solutions to support their work. I love the idea of, disintermediation and disruption, but I don't actually want to disempower the public interest legal sector in our work. And so we've looked for ways that will both provide tools to let people do the work in the ways they're doing now more effectively and efficiently, and also rethink how they define the opportunity. And one of the interesting thing, and the other thing that makes me put up this legal empowerment quote, is thinking about the fact that when we talk about access to justice and we try and quantify it mostly here in the United States, at the end of the day, it usually comes down to what percentage of people have a lawyer. It seems to be the most compelling way to define what the access challenges are. You know, only 1 out of 9 people who qualify for federally funded legal services actually get a lawyer. But one of the things I think we need to ask ourselves is, should in fact we be defining justice as access to a lawyer? And it's an open question, the idea for me, and it's something I hope we can talk about, is how valid the concept of legal empowerment is. And I just put up another slide. This comes from, if folks are not familiar with the Consumer Financial Protection Bureau and their fantastic work that they're doing in many different ways to make consumer information and tools available to people, but also in using data to track complaints about financial institutions and hold them accountable in real time. Really remarkable work, and they have, in the financial context, they've come up with this notion of financial empowerment, which takes traditional activities that were directed towards financial education and financial literacy and tried to define a space in which the combination of that education and literacy combined with tools that enable people to take actions would constitute financial empowerment. And I think it's sort of interesting to think about, both as lawyers and for those of us who aren't lawyers in the room, what the validity of that is in the legal context. So I'm going to now, I've wasted most of my time I promised to use, but I'm going to be really quick from here. So our work, just really quickly, and this is a part lead into Wilmeda, as our name suggests, Pro Bono Net, we started in the sort of lawyer support area, and we have systems that there are 90,000 lawyers around the country use and access to get sort of knowledge systems to help them engage in public interest legal work. But increasingly, a lot of our work is consumer focused. So lawhelp.org is, we have 25 states around the country that operate consumer legal information platforms with the best of breed content from the public interest legal community here in New York. If you've never gone to it, lawhelpny.org. Will is one of the people who works at Law Help New York. Is both a place where information and people can find how to get access to legal services available, but also increasingly it's kind of we think of it as a spine on which experimentation and really interesting new ways of delivering services. Like if you look on the right-hand side there, that Live Help is a service that's operated by law students here in New York State, available, I think, just about 5 or 6 days a week, all hours of the day, in English and Spanish. Think of it as like when you go to Land's End and you expect to have somebody chat with you, and they're not going to knit you a sweater out of chain mail if it's not in the catalog, but they are going to get you to what they have and help you find. And so that's been a strategy that's been used to try and make the websites and the information more accessible to a broader group of users. And the challenge is not the technology, which is trivial, but again, it's that question of capacity. If the public interest legal community wanted to offer this service, who would do it? What training would they need? How would you make sure that the service supported best practices in that area? And we support Live Help initiatives in about 14 states that all use different models, some involving law students, some involving hotline staff, some involving attorneys who end up doing legal representation work that is initiated initially in Texas through those online chats. And then the other sort of really important tool, I'm just curious, how many people recognize this image here? So very small number, which is, it's not mine. This software, it's interview software that was developed out of Cali and the Center for Computer-Assisted Legal Information and Education in Chicago Kent Law School is involved, developed A2J Author. And it is a interview gathering system that has been used in coordination with document assembly software. I think Pro Bono Net probably operates one of, if not the largest, online legal document. Last year, 1 million people used Law Help Interactive. This year, more than 500,000 legal forms will be created by people. All of those forms created for them with contextual help and video and multilingual support for people. All of the content created by the public interest legal community, law schools, courts here in New York. The New York State courts use this system for their DIY forms, their do-it-yourself forms. And increasingly, while these self-help tools are really important, and clearly the Docracy folks have gotten onto something that way, they're also really important as providing a new capacity for the public interest legal community and their allies to think about setting up services that add value on top of these things. And so I'm going to jump into really quickly, and now I'll start talking quickly. Just a few last things that dig down into the immigration space, and I'll just jump through a few things. About 10 years ago, which was not coincidentally the last time that there was a sort of serious political discussion about comprehensive immigration reform. Pro Bono Net was originally incubated out of the Open Society Foundations here in New York. And one of our program officers there introduced us to some folks from the Catholic Legal Immigration Network. I didn't know in 2004 that the Catholic Church was the largest provider of nonprofit immigration legal services in the country through diocesan-based, as folks may know, in immigration, you don't have to be an attorney to practice. You can work at an organization which has been recognized by the BIA and then become accredited to actually represent people both in affirmative proceedings and also in court proceedings. And the Catholic Legal Immigration Network was trying to think about, well, we were really involved the last time there was a mass legalization. If 20% of the people that came through that legalization program in the 1980s, if we expect the same 20% today of the anywhere at that point between people were estimating 11 to 18 million people, how would we have the capacity to do that? And unlike in the 80s, when all of 90% of those people who were eligible for those programs were probably in 7 urban centers, now they're all over the country. And so we got together and we talked with them about, well, how would you support your network? And do you have all the capacity that you need? And could your one organization, if we were able to train and support your people, is that the way to approaching organization by organization or network by network capacity? Is that the way to think about solving an access problem? And to their credit, they said no. There's other folks that we would need their expertise, and there are other organizations that we'd need to be doing that work. And so we've engaged with them in pulling together a lot of the major national immigrants' rights organizations, and we used a really great, was written in the early 2000s, and it was a really fabulous report that Suzette Brooks-Masters, who's now at the J.M. Kaplan Fund and runs their immigration program, and Ted Perlmutter, who some of you may know, I think he's teaching at Columbia now, did, that was looking at how the immigrants' rights sector was using technology for communications, service provision, and where the gaps were. And we brought people together and we said, let's update this report. And we had Suzette interview all the organizations that we're bringing together for convening, and we tried to identify where were the places that there were gaps in capacity, and what are those things that groups felt that they could solve the challenges on their own, and where would they be willing to give up their own individual control and do something as a group. And then out of that was the Immigration Advocates Network. And initially it was focused on training and support. And one of the first things it did was actually map capacity. Got all the groups that were maintaining different directories to agree to put it all in one online system that would then be able to be used. And there are APIs for it that make this available for iPhone apps, for other websites to use, for SMS text messaging campaigns that organizations I've never even heard of use to refer people to how to find nonprofit immigration legal services providers. And in the initial lift for it, and one of the points here is, when Bill Clinton was running for re-election, and everybody in the Clinton campaign apparently said, every day, it's the economy, stupid. It's the economy, stupid. Every time I come to a technology conference, every time we're doing something at Pro Bono Net, we always have to remind ourselves, it's the content, stupid. It's not actually the technology. And actually, in the first period, it's the content, and after a while, we have to remind ourselves, oh, wait a second, it's not the content that's the most important thing, it's the network that's the most important thing. We've developed some really very cool apps and online systems like Citizenship Works, which is now used by immigration legal services providers all around the country, including a network of 28 centers here in New York, funded through the New York State Office for New Americans, to be opportunity centers to provide naturalization services. Most of them are organizations without native legal capacity. And they use a network of 4 ONA legal counsel that provide backup expertise to them. In this system, you can go to the Brooklyn Public Library every month. You can go to the Queens Public Library. And in programs that are being promoted not by legal organizations, but by the public library, see what happens when people come in and are able to engage at the centerpiece amongst all the other things on this are one of those online interviews with the interactive forms that engages people and actually helps to, I only have like 3 minutes ago left. So now I'm really going to get really quick. But I feel like it's important. A lot of this stuff I didn't do, my organization didn't do, but I think it's important for people in this room who look to the nonprofit sector as the place that maybe they would provide pro bono help to think about what are some of the really exciting and cutting edge things and ways that people are using technology. So in addition to, this is now being used to provide remote distance services that would allow one lawyer in a legal services organization in central Charlotte, North Carolina, to provide naturalization assistance to clients in a 40-mile radius where it would take people 3 hours to drive and get into downtown. So in thinking about how do we address distance and what was really interesting, and this will be the last one, and then I'll save the other slides for when we don't have anything to talk about. We took the model for Citizenship Works, assumed that there was lots of things that a person could do on their own, but at the end of the day, they needed to talk to a lawyer. So at the end of the day, they had to go in for an in-person service. When 2 years ago, this June, the Obama administration announced the Deferred Action for Childhood Arrivals program in June 2 years ago and said, as of August 15th, less than 2 months from now, we're going to have this brand new program. There's going to be new applications that we haven't shown anybody yet, and we haven't developed them yet. Young dreamers are going to be eligible to apply. It was amazing to us that because of the work that had been done up to this point, people in the public interest legal community immediately said, oh my God, there's got to be an online solution to this. There's got to be something that is going to help us. Can we take that Citizenship Works thing and do it for DACA? And the dreamers who were driving the legislative agendas and driving the political agenda said, hey, wait a second. Our families have been being, misused by lawyers for years, not being helped adequately. We want a system, and we're going to need lawyers to help us, but we want a system that is going to be self-service so that if we want to do it ourselves, we can do it ourselves. And so Own the Dream is, in fact, a self-help service. If somebody gets through all of the red flag checkers and the logic, they can do it themselves. And it's been an incredibly, in thinking about what the, and as we've, since this rolled out mobile apps around these tools and texting campaigns that support both people understanding what their rights are and how to get access to services on the one hand, and then the youth dreamer networks promoting their advocacy agendas through to the same audiences that we have been able to bring together. I think going back to this legal empowerment question and thinking about what is the purpose of law in a society, if not ensuring justice. really thinking about where are the opportunities, not just to be more efficient in our outreach and get more people in to use our stuff, but in thinking about embedding the access services that we provide in organizations that are present in communities all the days of the week that lawyers aren't there. How can we, in the moment of providing service, also connect people to those, if I knew how to jump the slides back, I'd do it really quickly, all of those organizations and institutions in their communities that could actually help deliver on their lived experience of justice in their lives, whether it's low-wage worker organizing, housing advocacy groups, groups that organize around access to benefits, all of those different things that would help maintain people's livelihood and support. Because the last thing, and then I'm not going to talk when they ask questions. The last thing is, I love the Shake Law people. I saw them at reInvent, got in touch with them, love what they're doing. I love the Tiny Law. But what's sort of not so funny about that notion is that in the people's courts, within the view of the legal system of what tiny law is, people lose their homes, their families get broken up, and they get deported every day. That's tiny law.
All right. Let's have a... We're going to hold the questions until after all of our panelists have spoken, and that's a segue into Welneda, who is here from Law Help. And
great.
Get the clicker. Go.
Yep, I have a clicker, and all right, excellent. I'm Welneda Negron, and I'm the program coordinator / I look at technology innovations for Law Help New York, and I'm probably going to tell you something that you're not used to hearing, and that's that I'm actually very excited and optimistic about the legal industry, and especially in regards to access to justice, because as we all know, necessity is the mother of all inventions, and due to all the limited funding that is happening through the state and the federal funding channels, along with a lot of what Mark said about a lot of the access to justice needs, there's a lot of creativity that's coming out, a lot of really interesting partnerships happening, whether it's law and doctors partnering up to do early legal interventions in hospitals, whether it's lawyers partnering up with graphic designers to make law easy to understand, for people to grasp, whether it's legal law partnering with technologists, which is a lot of what Mark does. There's a lot of partnerships that are being born out of this great need, and a lot of really amazing things coming out with very limited funding that you can only imagine if there was more money available, that how much more issues and concerns we would be able to address. So for Law Help New York, I'm just going to talk very briefly about some of the things that we work on a very, very shoestring budget. And the Law Help New York project director is actually sitting up there, but she's right on this picture. So in our job day to day, when we look at how we can use technology to make the law more accessible for people, there's essentially 3 different ways that we've noticed. One of them is that technology is an information source for people. So through partnering with Mark and other people at probono.net, we have a legal information website that's in English, and it's also available in Spanish. And then a lot of this is going to sound repetitive, I'm sorry, but we also have a live help capability, which Mark talked about, and that's basically, I believe that we've even had Brooklyn Law School students that have volunteered as part of their hours that they have to do to man this live help operator, and it's really fascinating. I'm not a lawyer, and I've actually gone ahead and I've chatted with a few people, and it's very real, it's very raw. A lot of these people visit the website and they have very immediate needs, whether it's an eviction proceeding, that they're going to eviction hearing that week and they don't have a lawyer. What kind of resource, what kind of legal information can we connect them to? So we don't provide legal information. We only help people. There's a lot of information on the website, so we only kind of walk people through the steps of where they would be able to get that information, or maybe send them a link to a Know Your Rights resource. So that service is available in English and Spanish. We also, last year, we received, again, thinking about technology serving as an information source. Last year, there were almost 69,000 people that went to our website, and they used the website through a tablet or their phone, their smartphone. So we're actually developing a mobile version of the website to make it easier for people to maneuver and get to the information they need. And then we're just now working on a pilot project. It's an SMS text messaging. We're piloting it for 3 different counties in New York. And it's targeting immigrant women that are victims of domestic violence. And through this SMS text messaging campaign, they'll be able to dial in a certain number, a specific phone code, and be able to be linked to information. So it's technology's kind of driving the expectation that people have immediate needs, and instead of them going on Google, because I'm sure we all go on Google and we say, you Google questions onto the search box, and I'm sure that people, and based on the search that I do of Google results, people do search for, I'm being evicted in Brooklyn, where do I go? And we don't necessarily want them to be Googling those things, although hopefully in the first page there'll be relevant results. But we do want to answer to that need for the expectation that technology is creating, that people want to be able to access the information they need fast, and they want it to be reliable, and they want it to be useful. So a lot of what we do with live help and with the SMS text messaging and the mobile phone is to try to answer that need that people have for fast information, especially when they're dealing again with immediate need and not having a lawyer that can guide them through the process. And then the second thing that technology does is that it's a communication tool, and it's a communication platform. And actually, some of my slides are out of order, so they won't link in completely. But one thing that we're trying to do now at Law Help is that there's obviously a lot of data that's being made available through New York City and New York State. And we're exploring at how we can engage people with that data, how we can use it to empower a community, more than one person, and you'll talk more about that, I'm sure. And so we're tapping into data, and this is just a Google heat map that I did using 311 heating data of people that did heating complaints. And we had, through visualizing that data, we found out the neighborhoods that had the most heating complaints. And then I sent out a few emails and did some targeted just online outreach to community groups that work in those neighborhoods, and notified them that they may not have the resources to tap into this data, but just gave them the information. This is a visualization, a map that shows your neighborhood. There's a lot of heating complaints in this neighborhood. Here are some Know Your Rights resources from this website that you can give, that you can be proactive and give to your community. This is an ArcGIS using GIS visualization tool. This we're still working on, and it basically it's going to layer. These are the different broken down by county. It's the divorce rates broken down by county, and the darker counties are the ones with the highest rates of divorce. But in the legal aid community, that's actually, divorce is one of the most researched topics on our website. And as we all know, 2 years ago, it became easier to get a divorce in New York, but there's still a lot of, it's a great need, and there's a lot of lack of resources. So that's just another way that we're using data that's out and available to just be more targeted with the content that we develop and that reach. Then the other thing is that technology helps to create communities, and it helps to foster networks, and along with making the information easy to understand, we've created a blog and have adopted a community service media model, which is we target social service organizations. So there's a lot of flashy news websites. Why can't information that's helpful for people try to adopt some of those elements, try to engage people in an interactive way and in an educative way, and in a way that people are used to, going on any website. So this is actually a blog that we haven't fully launched it yet, but it's Real NY, and it's hoping to engage social service organizations and people, low-income people in New York, to learn about their rights. Maybe you're not going to go to it every morning, but maybe it'll be interesting and appealing enough that you will be engaged to just be more interested in knowing what's going on in your community and what kind of resources and information are out there. And again, these are just infographics, another way to just kind of make the law easy to understand and more accessible for people. The last thing that I'll talk about is that we do a lot of social media work, so we're looking to learn about the way that people have legal discussions online and the way that our own network works. So we've used an open source software called Node XL. It's free and available for anybody to use. And we're kind of following certain hashtags. We're just kind of analyzing what kind of community clusters around certain discussions, who is actively seeking this information, who is participating in it, and what kind of communities are being built around these specific online discussions that we can, and how can that inform the work that we do at Law Help as well. So looking at a lot of what's happening on social media is important. And we've taken all of this information in hopes of making it easy to understand for legal aid offices. We've created toolkits that kind of take a lot of this information and just impart it in an easy to digest manner so that all the lessons that we've learned, we can pass it on to other programs. So I'll just pass it on for you to talk about.
Great, thank you, Wilneda. And our last speaker is Nikki Zeichner, who's the founder of the Parole Hearing Data Project.
Great. That sounds so established. My name's Nikki Zeichner. I'm an attorney. I was practicing as a defense attorney here in New York for several years before having a wonderful opportunity to study integrated digital media at NYU's engineering school, which is right around the corner. And so this is a project that I began while I was kind of in transition. I was taking a course with a woman named Beth Novak, who's speaking later this afternoon, who's a huge advocate for open data projects. And at the same time, I was also involved in representing a man who was appearing in front of the parole board who had been denied 9 times beforehand. So he was eligible since '96, and this was just this past fall. He was still in prison. So during that time, I was kind of I had a foot in both places in kind of technology and open data, and also creating a project for this class. And I was also working with this man and becoming passionate about his case. So I developed this project, which here is an educational tool for criminal justice research built on examining parole hearing data. I'm going to tell you a little bit about it, and hopefully this will work. I'm just going to click forward. Okay, so hopefully this will work. This is a video of the woman who introduced me to this case that I ended up getting tangled in. So do I just hit, or do you?
All right. Let's see if we can. I'll try it again.
Can you people hear this? No?
Let me just see if I can pick up the volume here.
He comes up, and each time they turn him down and they say these words. And every time that he comes up for the hearing, he gets the identical answer. Now, I have written the governor, I have written the mayor, I have written all kinds of people about his case. I've really given up now because I've been doing it for years and it hasn't worked. And he comes up, and each time they turn him down and they say these words, the nature of the crime. That's all the explanation we get, whatever that means.
So I don't know if that was audible to everybody, but basically I wanted to show this just because it's amidst all of this conversation about technology, that this is like the person behind it who inspired the project. And, really most of these projects are about human beings. So, but what she was talking about was just the nature of the crime, that, there wasn't really much explanation to the determination that was made. It was just all we hear is the nature of the crime. 30 years ago, some crime happened, and due to that, we're denying you continually every year. So what I ended up focusing on was just, I put this picture, but like opacity, right? Like there's no transparency here. And parole is a different issue from the civil legal services that we've just heard about, in that there really aren't any rights. So like know your rights trainings for people to go litigate in court if they're getting evicted, or to obtain a divorce. There is actually a legal process there, and I mean, it's kind of bold to say, but it kind of is not. There's kind of not a legal process for parole hearings. It's like completely based on sentiment. There's really no entitlement for release, even if you're eligible. So what I was interested in was just finding out what's going on. So let's see what I have here. Okay, so this I'll show you. I'll show you just a visualization based on a scrape that I created with a lot of help from the director of my program, Luc Dubois, who's a data artist. So what I ended up doing was I went on the Parole Board's website. Since I've been practicing, I kind of knew about the resources. So there's this interview schedule where they post all of the upcoming hearings for the next 6 months and in the past 2 years. So you can see, all the records of the guys and women who are appearing. They say the facility where they're housed, the date of the hearing, demographic information like race, age, things like this. So I scraped it all, and I started building a data set and cleaning a data set, which is a really enormous task because the data is super messy, but creating a way for people to start understanding the system. And then, when we understand it, because we don't have a legal system to govern what happens with parole so much, at least we can work with public sentiment and realize, okay, are these decisions completely contrary to what we believe the public interest is, or do we believe that they're reasonable? So that's kind of where I started. And the scrape, I'm going to try to run this. It's just a video, but of this scrape that there should be, there is, it's just invisible, but if you put it, yeah. So basically, this is the scrape running. So, and it's hard to understand it, but these little numbers are age. And when the scrape is being run, I think it's paused, right? Yeah. When the scrape is being run, the bar graph kind of grows per each record from the parole interview schedule from the Parole Board's website. So on the left, I guess this is my right, your left-hand side is by race, and then here is by age. So from this first visualization, we started to realize that there was this spike in people who were appearing in front of the Parole Board at around like age 48 or so. And that was like a really interesting thing to learn. It kind of made sense, right? Like a lot of people who are in for violent crimes are serving sentences of like 15 to 25 years to life. So, 48 minus 25, let's say, is around 23. That makes sense. That's when a lot of people get in for violent crimes, which are the types of crimes that end up in front of the parole board. So this is like really valuable information. We can kind of make assumptions about older people and whether they are dangerous to society. How does that maybe impact the arguments we can make for somebody's release in the future? And what I ended up realizing also is that looking at parole data could be enormously helpful for all criminal justice research, because you're really getting a story after a whole period of incarceration. So we can learn things about how certain facilities are impacting somebody through time and whether it actually prepares somebody for release. Or, we can learn a lot just beyond parole. So it's a really exciting thing. And I just wanted to mention briefly that Wilneda was talking about using data to then go back into the community and realize where the work needs to be done. So one thing that I really would love to do beyond scraping, scraping helps us kind of move forward with this idea of who's watching the watchmen, right? Like, let's hold these systems that govern us accountable. But then also, I want to implement other ways to get people to participate who have firsthand experience with the system, so that we can get maybe crowdsource hearing transcripts, so we can also get their narratives in to help define this issue, because scraping data is really only pulling data that the government's provided you with. So they're kind of defining it to some degree, and participation is a really big part of that as well. So.
Great, thank you, Nikki. Jonathan, how much time are you going to give us?
We're running a little bit late, but we're okay. We can push everything back just a little bit. So time for a couple questions and from the audience.
Yeah, and I want to allow the audience to take some time and leap in here. There's one question I want to ask at the outset. There's a tendency to view legal problems that are unaddressed as low level. We talked about that this morning. The kind of things that are suitable for what you might describe as the one-size-fits-all solution. But each of you have talked about the fact that many of these problems are in fact fairly complex. They involve discretionary decision-making, highly discretionary decision-making, where a one-size-fits-all approach simply won't work. Immigration law also simply doesn't match this paradigm of something you can get a form for. So I'm wondering if all of you would reflect on the difficulties of using technology, which works very well for mass-produced solutions, in a context in which many of these real-life unaddressed access to justice problems can't really be resolved through a one-size-fits-all methodology.
I think we should. So, in the immigration context, the opportunity that I see is to use the technology to better enable lawyers to be available to handle in the medical profession, the public health profession, where they talk about getting doctors to practice at the top of their license rather than, Judge Littman here in New York. He uses this image when he talks about state court. He says state courts are the emergency room for the social ills of the 21st century. The first time he said that, I thought, oh, that's really good. It's not a biblical quote, finally. No, but then I heard him say it several more times, and I thought about it some more, and I thought, well, okay, an emergency room medical practices aren't what we maybe want to aspire to, but why? I had teenage kids at the time, and I spent a lot of time in emergency rooms, and we spent very little time with doctors. We spent time with people who, because of established protocols and the intelligent use of technology, were able to assess and triage and make sure that the doctor was spending time on the issues the doctor needs to be spending time on. So similarly, with the example that I was showing about the remote video consultation where a lawyer can't be in all those different places, how can the technology be used to allow sort of non-lawyer participants in justice networks do more of the work to gather and tee up so that the lawyers can actually spend time dealing with the more complex issues.
Any other thoughts on that?
Yeah, I just think that computers save time. I mean, you can just you can make things less complex, or at least a lot of the work less complex with technology.
Let me ask one other general question before I open it up to the audience, and that is where you see the principal problems in expanding technology, these labor-saving efficiency mechanisms, so as to address unmet legal needs. Where are the roadblocks, and how can we resolve them?
I have I have one thing to say, which is lawyers. I think lawyers are a roadblock. I think that, like I've found when I've tried to approach this idea of crowdsourcing legal documents, something that I'm really fascinated with, because I think like transcripts of legal hearings are rich sources of really, really vital information. I get a lot of pushback from attorneys, and I believe that it's for a few reasons. I think one is just complete lack of understanding of what would be done. So like they just don't understand the idea necessarily of working with data in this way. It's just not part of their practice. They have a lot of responsibilities, and they're just different ones. So kind of there's this understanding gap that makes it difficult for lawyers to be able to trust technology, especially when they have the responsibility of, keeping and protecting their clients. So I think that's like one huge roadblock. What else did I have to? Oh, and then it's also self-preservation, right? Like lawyers kind of have an incentive to disservice their clients in that respect and just keep protecting themselves, and first and foremost before putting information out there. So
I was gonna just quickly say two other roadblocks. I would say it's definitely sustainability. A lot of these projects that have an impact, they receive just limited funding. So even if for 6 months we're able to prove that we've reached thousands of people, that doesn't mean that we'll be able to do it next year. So sustainability of these technology projects are really important, and the funding is still limited. And the other one is managing expectations of people, the client end. And the more accessible that you make yourself, and the easier that you make it for them to also, chat with, post a comment on one of the blogs or send us an email, also sometimes gives them the impression that they will be able to get advice from or assistance very rapidly. So I think a lot of times we just have to manage people's expectations that access doesn't necessarily mean that, and kind of going back to what Mark said at the beginning, doesn't mean that you're going to get a lawyer through going on the website necessarily, or that I'm going to be able to email you legal information. It means that I can only supply you with the tools and with the information so that you're just better informed. So it's kind of, for the meantime, it would be great to do more stuff, but it's good to just kind of manage people's expectations about the technology. And I don't know if you have anything else, Mark.
Yeah, I mean, well, the legal system is not a neutral space, is another one of the barriers to it, and there are different institutional interests. I mean, it is fantastic that the courts here in New York State have been championing the cause of civil legal services, have been championing access to justice. A huge amount of work that's been done that's really great, but we also need to look and kind of go, well, wait a second, what does it mean when the courts actually are administering and setting up programs to provide assistance, and what's driving, what success is? What success is from the point of view of making the administration of justice more efficient, which will improve access to justice regardless of the outcome in any individual case, is very different than the perspective of an advocate who, in this. So and it, it is, as Will Nettie was saying, a lot of it has to do with just resources. I mean, it's just almost laughable the amount of funding that goes into beyond funding civil legal services in this country, but going into funding technology and innovation is actually extraordinary. The Legal Services Corporation set up an independent funding stream about 10 or 11 years ago, the Technology Innovations Grants Program, that at its height gave out, I don't know, $6.5 million a year. Now it gives out, like $2.5 million a year. The return on investment that they've gotten for that money in terms of proving how a little bit of funding can really incentivize people to think differently is extraordinary. But in terms of the magnitude of the problem, we're just in early days, the work that we're doing.
So the problems are high expectations from clients, the lawyers are in the way, and there's not enough money. Those are big problems to solve. Let me open it up to all of you for comments, questions, etc.
Hi, I'm Leah Margulies. I'm the project director of Law Help New York, and I also want to say I'm a Brooklyn Law School graduate, so it's really delightful to be here. What Mark and Wilneda didn't actually say is the scope of the problem, and I think people really don't understand it. Last year, 3.2 million people in New York State went to civil court without an attorney. And what that means for somebody who's about to lose their home or their children, it's extraordinary. So I'm just urging people to get involved. Now you have pro bono credit requirements. Our Live Help program engages 125 law students from around New York State, mostly New York City, not that many from Brooklyn Law School, each year in providing pro bono services through Live Help. Most of them are coming from Columbia and Truro, and I always wonder, why aren't they coming from Brooklyn Law School? So this is a challenge. Please join us in this. We also do an enormous amount of social media, and we had about 90,000 people visited our social media related to Sandy resources. So
in defense of Brooklyn Law School, I think perhaps we've got 31 clinics, more clinics than any other school in the country, I believe, and I think they're probably working on some other issues, but certainly we should
I told you it was contested terrain.
Certainly one problem we can at least work on.
First of all, I want to commend all of you for the work you're doing. It makes you feel proud to be a lawyer or to be involved with that. So something that was just addressed, all of you are doing consumer-facing work. To what extent are you using technology, social media, and other tools to make consumers aware of what you're doing? Because I think that, I think part of the problem that you have is there's not enough people aware of the resources that you're making available to them. And doing a simple Google search is not necessarily going to enable them to find out what you're doing and, what the availability of your services are.
Yeah, outreach is a big part of these initiatives. Actually, happily, if you do search for most common, legal problems in New York, you will get Law Help up pretty high on that first page, which is a good thing. We've also used Google Grants and other things to, essentially be able to place Law Help high up in there. But, when we first proposed doing Law Help here in New York, we had two reactions from legal aid lawyers who were skeptical about it. One said, my clients will never use the web. And the second said, there are more people finding our office today that we have to turn away. Why would we ever want to let anybody else know how to find us? And in fact, both of those things were true. And it wasn't until we engaged in doing this work and were actually able to, show that these tools would allow them to do more and make different kinds of services available, and that in fact, access to online information was changing. But a lot of the outreach strategies has been involved around what are the other brick and mortar access points to low-income people finding help. So a lot of work has been done in partnerships with libraries, like the Citizenship Works things. And what are other community institutions? Constituent services offices of city councilmen love these things. They're making sure that awareness is high in settlement houses, and is a more is sort of unparalleled to sort of buying AdWords and mass marketing of these efforts. Really been the strategies that folks have done. In Montana, they did a fabulous thing. I love this. I'm waiting for somebody else to replicate this. They did a series of common legal advice coasters that went into bars. But I haven't seen anybody else do that yet. They seem to be more interested in subway ads.
Great. I think we're running late, so I'd like us to all head up to the lunch workshop. Now, this is an experiment. I don't know if this will succeed or fail, but this is an effort at crowdsourcing civic participation. Depending on how many people we have in the room and how many people grab the mic, we are going to try to create the Citizens Charter for cyberspace. So I'll see you upstairs. Elevators, best elevator. Well, there's elevators here.
And before you go, a round of applause for our panelists.
Nice. There are 2 elevator banks. There's elevators here. If you take them to 9, you'll have to walk around and then go up another flight of stairs. And there's another elevator.